Ms. Dyke to testify first?
I'd like to go first.
Okay, so sir, start out with your first name, your last name, and then give me your statement with regards to this issue.
My name is Patrick Dyke.
First name, last name, and statement.
And we were unfortunately all sucked into a defective title issue. And unfortunately, the local title agent was trying to avoid making a claim. I was hoping that a claim could be made, and I was able to receive no claim number. So actions were taken as personal representative to secure property that remained in my grandfather's name. And this became complicated, and ultimately false information was sent to an insurance provider. This would be Exhibit 1. I don't know if you want me to address Exhibit 1 at this time. I would like to present it. It's pivotal in this matter. So we were...
My assistant has a copy of it. She's going to give it to Mr. Byers.
Okay. We live about a mile from this disputed property, and Antoine Tissot, Mr. Byers' attorney, at one point lived next door to the disputed property. He now lives about 700 feet from the disputed property. From our understanding of ORS 20.080, the core intent of that is to encourage pre-litigation pre-litigation resolution. So this demand letter in Exhibit 1 was it should have been an attempt at pre-litigation dispute. Resolution. However, we have firsthand knowledge that people by the name of Mears lived on the property. We had homeschool dealings with that family in 2017 and so forth. So when there was conflict at the attorney's office, and I tried to deliver a document, and it was refused, and I was upset. And so when I got a demand letter, the one you see here, I refused it. The mail carrier presented both the plain and the certified copies, and I refused them both because I tried to deliver a document and the attorney refused it. So I had really no reason to believe he even represented Mr. Byers. Ultimately, if we were to have gotten this demand letter, we would have strongly disagreed with it, as it purports that Mr. Byers is entitled to exclusive possession and quiet enjoyment of the property. And we knew that renters were there, and we knew he lived 100 miles away. So Mr. Byers, in the lawsuit that followed, maintained that he had actual possession for 18 months. And we put in a motion to dismiss, and we cited Oregon Supreme Court case law showing necessity of possession for trespass. That's also in William Prosser's tort law book. We discovered necessity of possession in good faith. We shared that with Mr. Byers' attorney, and which happened to actually be the title company's attorney. In my request for admissions, Exhibit 4, which I'd like to go over at some point, the plaintiff's attorney admitted they didn't even know if the property was in possession of tenants. So in ignorance, the title company, likely based on this defamatory demand letter, commissioned a lawsuit against us, and the big law firm Schwabe, Williamson & Wyatt, they didn't confirm anything apparently. They just sued us. And then when we said, hey, we found necessity of possession, they said, it doesn't matter. We don't know if it's being rented, and it doesn't matter. So this is a very complicated case that involved 4 attorneys over an extended amount of time. I'm so sad that the matter has been complicated. I would have preferred if Mr. Byers, I tried to exhort him to submit a title claim directly to the underwriter, and I don't know what happened. He could have submitted a claim online, but nonetheless, an attorney and attorneys got involved. It made it very complicated. So we suffered 13 hearings and an expense of about 20 hours a month. That's conservative, over a 1.5 to 2 year period contending this. We didn't have really funds to afford a lawyer, and so we tried to concede the property to Mr. Byers several times. His attorney early on, well, actually Stuart Title's attorney early on said, if you concede the property, we drop the lawsuit, would that be okay? And we said, sure. But Mr. Byers apparently was wanting a monetary amount to settle the trespass issue. And we even signed the quitclaim deed that the Mr. Byers' attorney offered. We tried originally to let him win by not responding to the original lawsuit, which was against the estate. And that wasn't good enough, and so they had to refile it, and it just got increasingly complicated the more time went on. So the property was sold after the quiet title was finalized, Claim 1. That was, Mr. Byers sold the property in December, and so basically we're just trying to recover from this situation, and we feel that the elements of defamation have been met. We didn't get the defamatory Exhibit 1 until November of last year, so we're within a year on any statute of limitations on defamation.
Sure, I understand what your claim is. You're claiming that demand letter is the defaming document?
Yes, sir. If you're looking at it there's a page labeled Byers 0023, first paragraph. Mr. Byers is as owner of the property, Mr. Byers is entitled to exclusive possession and quiet enjoyment of the property. We have since discovered the lease, and in Exhibit 2, you can see that there was a point in time where Mr. Byers reversed his position regarding actual possession. And he admitted, finally, belatedly, in October of 2019, that as of June 10th, 2017, as a landlord, I leased the Byers property to Dylan and Molly Mears.
Okay.
There's further evidence in Exhibit 3, where it says that the tenants didn't want to get involved in a lawsuit. So we see this as an attempt to use the trespass claim in order to bully us to concede the adverse possession claim. I don't know how, I mean, I could spend hours. When I consult with the attorneys through the Oregon State Bar referral, it takes a long time just to explain this complicated situation. So I'd kind of like to limit it just to the basics of, is this not truthful, and go from there.
All right. Any other statement for me, Mr. Dyke, from you?
Well, we did take actions to secure the lot. At one point, a for sale sign was put up on the lot because Mr. Byers appeared to have abandoned it. And in my request for admissions, there's material that supports that, and that's Exhibit 4. There's material in Exhibit 4 that show that nothing was done to mitigate damages, and overall, we feel an effort was made to fabricate damages and enhance the fabricated damages and so forth.
All right. Anything else you want to tell me, Mr. Dyke?
I'd like at some opportunity at some point, the opportunity to call Mr. Byers as a witness.
All right. We'll get to Mr. Byers if he wants to make a statement. But right now, I was just talking about you, sir.
Okay. I think that's all I have for
Mr. Byers, is there? Okay, thank you, Mr. Dyke. Mr. Byers, is there a specific question I need to ask Mr. Dyke?
How was the property abandoned?
Mr. Dyke, if you can answer that question.
Yes, we posted sign. Well, we gave Mr. Byers a permission to use paper because during the dispute, we weren't trying to preclude his renter's use of the property, and we did. So we posted our own no trespassing sign, and there was a for sale sign posted there, and the for sale sign was left there for 3 months, and Mr. Byers never contacted us. The renters never contacted us and said, you know, this is really kind of a nuisance. Could you do something? They never did anything to let us know that they were maintaining any active interest in this small disputed lot.
And they grew up in weeds.
Yeah, it grew up in weeds. And we were worried because of the hostilities with the renter. We were leery about going over there and trimming the weeds.
All right. Any other statement that I need to specifically ask Mr. Dyke?
You say you were leery about going over there because of the hostility. Did you provoke some of the hostility by repeatedly driving into the cul-de-sac and, I guess it would be my opinion, of harassing the renter?
I don't believe so. There were times I wanted to take photos, and when I was there, I alerted Mr. Mears that I was there because I didn't want him to. I saw him outside. I didn't want him to accuse me of like sneaking around. So I said, you know, I made my presence known, not on the property. I was just trying to say this is a title insurance matter. Tried to explain that this is a title insurance matter, and it seems like nobody appreciated the significance of there being title insurance. I mean, Mr. Byers' deed, it was a warranty deed, and I knew enough to know that it should have been their responsibility to deal with this, and I was only wanting the title insurance to take care of it, you know, in the way that they normally do. Unfortunately, like I said, the local title agent, I have discovered documents that showed that they were looking for the least expensive local solution possible, and so it appears the local title company was trying to avoid making a claim, and that put everybody else in a real awkward position. Does that answer your question?
Mr. Byers, any other questions for Mr. Dyke?
Can I follow up?
Hold on.
No.
All right. Mr. Dyke, what was your follow-up, sir?
Well, I have tried to be very courteous. I saw Mr. Mears in town and just at an intersection, and he gave me the finger and he mouthed, the F word at me. So I have not been vulgar or I haven't reciprocated to his animus.
All right, thank you, Mr. Dyke. Ms. Dyke, would you like to give me your statement now, ma'am?
I don't really have any statement.
Can you tell him how you knew them?
Oh, Patrick just wanted me to tell you that we
Hold
were.
on.
Okay,
Hold on.
sorry.
Hold on, ma'am. You have to tell me your first and last name before you give me your statement.
Okay, my name is Heather Dyke, and Patrick wanted me just to be a witness to the fact that Molly, we were acquainted with the Mears through our homeschool group, and we knew that they were renting that house that Mr. Byers owned, and that he wasn't actually in possession of it during the time of the adverse possession part of the lawsuit.
Okay, any other statement, Ms. Dyke? Mr. Dyke, I need her to tell me, not you to tell her to tell me.
I can't think of anything else.
All right, Mr. Dyke, is there a specific question I need to ask Ms. Dyke?
I don't know of any.
All right, Mr. Byers, is there a question I need to ask Ms. Dyke?
Were you with your family in your van and driving through the cul-de-sac, and all of the family was waving and smiling at Dylan Mears?
I don't recall ever driving through the cul-de-sac and seeing Dylan there, no. I started going to town. When I would drive to town, I would deliberately avoid passing their house or driving that Cirrhosis Street along the edge of the park because I knew that they were hostile towards even seeing us, except for Molly. When I saw her in town, she was always still friendly, but Dylan seemed to be angry, and I just started trying to avoid ever going past the property when I would go to town or when I would take my children to the park.
Any other questions, Mr. Byer, for Ms. Dyke?
You don't even, let's see, how would I ask this? Is it necessary to drive down that street to even go to town in either direction? Isn't that the street that it's between? So it's easily to go either side of that street. So it's not like you had to go out of your way to avoid them.
Well, I used to drive along Cirrhosis Street, the backside along the park by the baseball fields.
Right.
And I started avoiding that because I would go that way if I was going like to a doctor's appointment or the dentist or anything. But oftentimes the mirrors seem to be in that area, either maybe in the cul-de-sac or at the park, and so I tried to avoid. I don't usually drive on 21st Street at all, but I was on Cirrhosis Street and started to avoid Cirrhosis Street.
The one that runs up the side of the park.
Right. And I don't have occasion to drive down 21st Street, but and I definitely didn't take my children there and wave and say hello to Dylan. I don't even know if I would recognize Dylan. I do know Molly just from homeschool activities.
Well, you just said he was hostile towards you.
Well, I saw him at one of the homeschool activities with his family. Their children are in the band, the homeschool band, and so we went to a band concert, and yeah, that was my recollection of seeing Dylan. It wasn't at the property. It was at a band concert at one of the schools in town.
Can you see the property from either one of those streets? They go around the park, not 21st Street. The house is halfway down the street in the middle.
I don't think so.
Yeah.
Not argument. You could just ask a question,
Yeah,
Mr.
you're right.
Byers.
That's all.
Okay.
All right, thank you, Ms. Dyke. Any other witnesses on behalf of plaintiff?
No, Your Honor.
All right, Mr.
Oh,
Byers, will you
other
be
than
giving me
Mr.
a statement, sir?
Other than Mr. Byers.
Well, Mr. Byers is giving me a statement now, Mr. Dyke.
Okay.
Mr. Byers, if you'll start with your first and last name and spell your last name, please.
Daniel Byers, B-Y-E-R-S.
All right, Mr. Byers, you may give me your statement, sir.
Okay. So a lot of this felt like we were doing the same case, and I understand we have to give some context. And in that vein, I actually have a document I'd like to submit that's in a motion in another small claims suit that Mr. Dyke's involved in. It does a good job covering the pertinent factual background to the case that this all stemmed from, as well as has a section on absolute privilege that might be pertinent. And he should be familiar with it because he's involved in it. It's a motion for attorney Nathan G. Steele to appear on behalf of defendant. But it'll give the judge.
Mr. Dyke, do you have a copy of that document, or do you know what that document is?
I don't have it handy here.
Do you know what the document is?
Yes.
All right.
I would like to object.
There's a sticky note on it, and it says Wasco County Small Claims Department, Patrick Dyke versus Shannon Tissot.
Yes.
Are you familiar with that motion?
Yes.
All right. Mr. Byers, you may continue with your statement.
Okay. So hopefully that will give context. And I'm just going to say right up front, I don't dispute that I and the lawyer, whatever, made the claim of, I don't even know what it's called, absolute, hang on.
Adverse possession.
No, that I was in ownership, or what I was in ownership, but
Actual possession?
well, it's what the complaint thing is. That I had exclusive use or whatever that was called. And at the same time that I had renters in the property, that I will not dispute that. And in the rental agreement, it says the same exact thing. I personally haven't been all that aware of what those meant at the time that this was all filed. And I'm going to focus on trying to do the defamation part instead of rehashing the whole thing again. So Patrick had called me in February, March of 2018, and had said that his grandfather had left him an inheritance, the back, I don't remember, it's 20 or 30 by 60 of my property.
Objection?
There's no rules. This is not a standard court case. This is small claims. So he can make a statement. You can ask him questions afterwards.
Thank you.
we had a conversation, I don't know, for a while, and at the end of that, I was like, and he did push me to, not roughly or anything, we were talking on the phone, but he calmly asked me to just file a claim, and I said at the end of this, I said, this conversation, I said, you and I both know that your grandfather didn't develop a subdivision in town and keep a piece of everybody's property. And he didn't even reply to that. He just went on to some other point. But it seems like at the end of that, or within a conversation, because we were talking at that time, I just had said that we, well, let's see what I can find out. Let me find out from the title company what they have to say, and then you wanted to put a no trespassing sign on. And at first I said, yeah, fine, whatever, I don't care. But then I got to thinking, because he was trying to establish an interest in the property after 50 years of not doing anything and 17 and a half, 18 years of not doing anything with the property that when I owned it. So anyway, I've lost my track there, but so I don't dispute that there was this misstatement, but I will say that I don't believe that either one of the attorneys that were assigned to the attorney I hired after Patrick parked the car on my property that week, or the other attorney, that any of us, including Patrick himself, was aware of this conflict. I know I wasn't. I have the notice that he posted on the property with the car, and it's dated March 16th, 2018. It says, to whom it may concern, the heirs of Lewis E. Nichols possess the original warranty deed for the property on the back side of 326 West 21st Street, known as Lot D, Bronx Addition, Lot D. The warranty deed held by Dan Byers is not valid in its inclusion of Lot D. The deed information has been reviewed with the Title Inc. and Columbia Gorge Title. Thus, Dan Byers is not authorized to have any property belonging to the heirs of Lewis E. Nichols removed from Lot D. Whoever signs any agreement to have any property removed from Lot D belonging to the heirs of Lewis be held responsible for making compensation for any losses incurred by the heirs of Lewis E. Nichols. Any company involved with the removal of any property belonging to the heirs of Lewis E. Nichols may also be liable for any losses incurred. If you want to verify ownership of Lot D, please contact Title, Columbia Title, or email your request to lewisnichols@gmail.com, and a PDF file will be sent containing images of the deeds involved, showing that the deed for Lot D was never conveyed to anyone by Lewis E. Nichols. He's addressing me. He's coming directly. He called me. And I'm not a lawyer. I don't want to be a lawyer. But so I'm the owner of the property, and in my understanding, I assumed that this is my issue to deal with. And I think it's fair to say that my lawyers believe that as well. And yet there was the conflict with the lease agreement stating the same thing. And that was actually discovered by Patrick himself in December of 2018. This is a email from Tammy McLeod to Antoine, my lawyer. Also, Patrick seems to be spending quite a bit of time doing legal research, and he's now questioning whether Mr. Byers has standing on the trespass claim. He's found case law standing for the legal principle that the proper plaintiff on a trespass claim is the person legally entitled to occupy the property trespassed upon. In more simple terms, because Mr. Byers had rented the property to someone else, that trespass claim belongs to the tenant, not Mr. Byers. My quick research seems to affirm what he is saying, but that does not account for the storage claim. We could amend again and bring the tenant as a plaintiff. His case law does not make the claim go away, but may affect who can prosecute it. So my point is, we were all operating when this was filed in March and submitted this thing to Patrick. All of us, including my lawyers, which I would think they would understand who a trespass is against, but it seems they missed it. It wasn't malicious. It wasn't willful. It didn't have malice. It was whatever. But from my perspective, I had no clue for the longest. I didn't even understand what point he was making. So I'd like to submit these to the court. And also just to show that he was planning all of how to do this and park the car, and he had gone to the city police and the code enforcement, because we had gone to the code enforcement and the police. Well, Dylan, the renter did. And he was told it's a civil case. We were aware of it, but it's a civil case and we can't do anything about it. So he had gone in advance. So as far as not taking care of the property and letting the weeds grow and leaving off, that's a very threatening sign that he posted. And if there was damage to the car, that property, then there would have been some other problem with Mr. Dyke. So, as far as it being the accusation of being malicious and defamatory, I'm a small business owner. I have my own business, and the rationale that is used in this case on his back point, that it's harming his business and that because it was filed in court. I could say the same thing right now about this case. I wasn't trying to be malicious towards Mr. Dyke. I wanted his car off of my property, and instead of him waiting for the title company to get back to me, which took them forever because they were dragging their feet and they weren't doing what I think they should have been doing. And I need as a lawyer to deal with Mr. Dyke and the title company to get people to do what is just right. So, I didn't intentionally defame, or I just filed a case to try to get him to remove his car, and there's my statement, I guess.
Mr. Dyke, do you have any questions for Mr. Byers?
Yes, sir. Can I begin?
Yes, sir.
When did you first discover there was a deed problem with the property known as 326 West 21st Street?
There was a deed problem.
When did the Mears go to AmeriTitle to try to buy the property and get title insurance?
I'm not sure exactly when that was. It was previous to March, probably a month or two before. Dylan had called me and asked, he goes, "What's this? Who's this Nichols? Do you owe him money for materials or something?" And I was like, "No, I don't know who he is. That's nothing. I don't owe anybody anything." So that was the very first time that I became even, although I didn't know what that meant. And then it was later, it may have even been you bringing it up that there was an issue.
So maybe January of 2018, Dylan went to AmeriTitle because he wanted to buy the property.
Yeah, I'm not sure of the timing, but he went there early. Yeah, it usually takes 2 or 3 months to. We were supposed to close on the property March in 2018 by the end of the month.
When did you first did AmeriTitle contact you and let you know there was a deed problem?
I don't remember if it was Carolyn Layson, my realtor, or if it was AmeriTitle.
And you first found out about that when?
I don't remember whether it was before. It was within a month or two of the you calling me.
Okay. Can I go on to my next question?
Yep.
Are you related to the Mears as family members?
No.
When was the idea of an assignment agreement first mentioned?
And a what?
An assignment agreement? When we talked to Tammy about this matter, she said, well, Mr. Byers not having possession is irrelevant because there's some sort of assignment agreement.
I think, and it may even be on that note, right around that same time, the conversation in emails I saw, that's when it all, well, Dylan will probably be willing to assign his right to it.
And when was that?
It was within, right around the December 18th email.
Okay, December of 2018, after the communication that you mentioned from Tammy.
Correct.
Okay. When did the Mears first indicate they did not want to get involved in a lawsuit?
Pretty much immediately.
Okay. So you've okay. Do you now believe, based on what you've learned, that you as a landlord are entitled to exclusive possession and quiet enjoyment of rented property?
I don't find that that's relevant to an allegation of defamation from the letter that was sent from Mr. Byers' attorney to you.
Okay.
I don't need that.
Okay. Early on, your attorney asked if we would concede the disputed property, she would drop the lawsuit. Did you or did you not agree to that?
Your Honor, can I ask, is this part of defamation, or, I mean, I don't have a problem answering questions, but it seems like he's trying to get more information from the case.
Focus around the defamation claim, not about everything else.
Okay. So to confirm, you've admitted that the content of the some of the content of the demand letter is not true. Correct. And as far as your damages, you claimed at one point $13,900 trespass damages. Ultimately, how did you explain how you got that figure of $100 a day?
I don't need that information. That doesn't have to do with the claim.
Okay. Well, it's. Let's see if any of my other questions might.
You can ask him specifically which statement was a misstatement.
Which statement was a misstatement?
He said there was a misstatement. You can ask him.
Oh, you said something about I don't dispute that there was this misstatement. What misstatement are you referring to?
And I had exclusive, I don't remember how you say it, but
So you're admitting it was a misstatement to say that you were entitled to exclusive possession and quiet enjoyment.
correct.
Okay.
This time I had him.
Yeah, I guess based on defamation, that's all I really need.
Okay, any other questions for Mr. Byers?
I don't think so.
Okay. So, Mr. Dyke, what I'm going to do is I'm going to take this under advisement for just a little bit of time. I'm going to start reviewing a few things. I'm going to review the documents that you've submitted as exhibits as well as Mr. Byers. And I'm going to have you call back in at 10:30 for my decision. So that's in 30 minutes.
Okay, sounds good.
All right, so please call the line that you called in 30 minutes at 10:30.
Okay, thank you.
All right, thank you. We'll go off the record. And
Bye.
Mr. Byers, if you want to step out, some other attorneys need to use it.
What do you think? He admitted that false information was. He admitted it as a misstatement.
That's all. Most of this was like. That's why I asked you, how does this relate to defamation? What you're getting at, you needed to narrow it down to. It was interesting that he admitted. I don't dispute that there was a misstatement. I'm like, oh wow, okay. I don't dispute. I and the lawyer made a claim of exclusive use, and at the same time had renters in the property, is what he said.
So we saw that they dragged their feet for like 2 months, a long time.
Yeah, he sounds like it. It's interesting. He sounds very humble, and he sounds like it was not as straightforward as he would have liked it to be.
What's your breakfast?
I think that it's all gone, but I don't know. I reheated the cream of wheat, and it was yesterday's leftover, so there wasn't a whole lot of it. The rest would go empty. I already did it yesterday. We have $20 to Spookies.
Well, what do you think he's going to do? I mean,
I have no idea. I was really surprised when he had as his exhibit Nathan Steele's 15-page motion.
that's totally unrelated.
I'm shocked
What?
that he had that. That was his exhibit that he
I mean, it's been proven that there was written defamation. Publication of false information to an insurance provider. Is he going to say, okay, it's been established and admitted, but
I really don't know. Are there more qualifications to be met? Does it have to be with malice? Because you were saying that wasn't with malice.
no. It's not an element of. So he's saying they didn't make up their assignment agreement until. So he's got a communication there that I haven't seen.
That was interesting, the one he read from camera.
They're supposed to, well, I guess they're going to say, well, that's a protected one.
Mm-hmm.
The logic is their error resulted in a lot of grief for everybody. Extreme amount of grief for everybody. He admitted that his attorney was incompetent.